The question that we are going to go over in this lesson is freely available for download on the National Conference of Bar Examiners website, which is www.ncbex.org. If you'd like access to more practice questions like the one we're about to go over in this lesson, simply head over to the National Conference of Bar Examiners website and visit the section on preparing for the exam. From here, you can download tons of free practice questions directly from the National Conference of Bar Examiners. This is an awesome free resource I highly recommend everyone check out. Additionally, if you would like explanations to more bar exam questions in the format of this video, you can always head over to our website at www.studicata.com. But with that, I'm really excited to get into this lesson with all of you, so let's just go ahead and jump right in. In this lesson, we're going to go over an evidence bar exam essay question from the July 2013 multi-state essay exam. So step one, the first thing we always want to do with these types of essay questions is head down to the bottom of the essay first to take a quick look at the call of the question. Oftentimes the call of the question is going to give us really important information to consider as we begin to actually read our fact pattern for the first time. So if we take a look at this call of the question, it tells us that defense counsel asserts the following. A, the caller's statements to the police dispatcher are inadmissible hearsay. B, admission of the caller's statements to the police dispatcher would violate the boyfriend's constitutional rights. C, the officer's testimony repeating the sister's statements is inadmissible hearsay. And D, admission of the officer's testimony repeating the sister's statements would violate the boyfriend's constitutional rights. This jurisdiction has adopted rules of evidence identical to the federal rules of evidence and interprets the provisions of the Bill of Rights in accordance with relevant United States Supreme Court precedent. How should the trial court rule on each defense objection? Explain. Okay, so this is a really robust call of the question. Very obviously, we are in evidence territory. It looks like we're looking at the admissibility of these statements, these out-of-court statements under the federal rules of evidence and the Bill of Rights in accordance with relevant United States Supreme Court precedent. Okay, so typically when we think about an evidence essay, I always tell students to think about evidence essays like hurdlers at a track meet, right? If we imagine the different lanes of a track meet and we have these hurdlers, right? And they have to jump over all of these hurdles to cross the finish line, right? And I always tell students we should kind of think about an evidence essay like hurdlers at a track meet in the sense of each of these hurdlers representing a different piece of evidence. And to get admitted into court, we say each piece of evidence has to get over all of these hurdles to be admitted ultimately into court. And usually the hurdles we're talking about are the federal rules of evidence, right? And so usually, right, our first hurdle that we say pieces of evidence have to get over, kind of our gateway first hurdle, is usually always FRE 401, Rule 401 of the Federal Rules of Evidence, which is relevance, right? We say to be admitted into court, evidence must be relevant. This is our gateway issue. So we always run through FRE 401 first to determine if the evidence is relevant. Right? And then we move on to our next hurdle and we keep going and we see if the evidence can be admitted into court or not. Does it get over all of the hurdles it needs to get over? So this call of the question, though, is a little bit different, isn't it? Right? It tells us exactly what hurdles to focus on. A lot of times what we get in evidence call of the questions is just determine whether each piece of evidence is admissible, right? So we have to think about each hurdle that the evidence has to get over. This is a little bit different, right? It's telling us exactly what hurdles to discuss. It's telling us hearsay, and potential constitutional rights violations. And because it's telling us what hurdles we have to focus on, it's not just asking the open-ended question as to whether each piece of evidence is admissible. It's asking, hey, look, defense counsel has asserted these objections, right? Should the trial court rule on each defense objection? How should the trial court rule on each defense objection? It's not asking you whether each piece of evidence is admissible or inadmissible. It's asking you to play judge and rule on each objection specifically, right? Each hurdle specifically. So this is one of the rare times on an evidence essay where we don't have to worry about relevance, Rule 401, right? We just have to analyze exactly what it's asking for, which it looks like it's going to be hearsay and potential constitutional rights violations. Which takes us to the next point, right? When we're thinking about hearsay and potential constitutional rights violations. So anytime we're thinking about on an evidence essay, constitutional right violations kind of interwoven with hearsay analyses, the first thing that should come to our mind in terms of issue spotting is going to be the Sixth Amendment Confrontation Clause, right? The Sixth Amendment Confrontation Clause is kind of an inherent problem in hearsay analyses where we're bringing an out-of-court statement into court, but the declarant who made the out-of-court statement is now unavailable to testify at trial. Because we know the Confrontation Clause under the Sixth Amendment guarantees a person accused of a crime the right to confront witnesses against him in a criminal action. This really gives the criminal defendant two major rights: the right to be present at trial and the right to cross-examine the prosecution's witnesses. Right? This is the whole idea of the Confrontation Clause. If somebody accuses you of a crime, the criminal defendant should have the right to cross-examine his accusers. This is the guarantee of the Sixth Amendment Confrontation Clause. So we can see an inherent problem in reconciling rules FRE, Federal Rules of Evidence, 803 and 804 with the Confrontation Clause. Because we know rules 803 and 804 allow out-of-court statements to be offered to prove the truth of the matter asserted in those statements. Those statements can come into court even if the declarant is unavailable, right? Think about the dying declaration, right? A person makes a statement on their deathbed, an out-of-court statement on their deathbed, and then that person dies, right? And then the prosecution comes in and introduces that statement. Well, that's a problem, right, with the Confrontation Clause, because the Sixth Amendment guarantees criminal defendants the right to cross-examine their accusers, right? So imagine a person on their deathbed makes some incriminating statement about the defendant. I saw him commit this murder, and then the person who makes that statement dies, right? Well, now the criminal defendant is not going to have the opportunity to cross-examine this witness because they're dead, right? But we know under rules 804, 803, and 804, a dying declaration could come in to court even if the declarant is unavailable. So how do we reconcile these two things, right? And this is what the Sixth Amendment Confrontation Clause kind of analysis, this is how it gets interwoven in our hearsay analyses. So like macro, big picture, anytime on an evidence called the question where I see something like this, where A tells us to analyze whether the statements are inadmissible hearsay, and then the next question asks whether those statements could be a violation of the Constitution, right? A violation of the boyfriend's constitutional rights. Well, the thing that goes hand in hand when I'm thinking about a hearsay analysis and a possible violation of constitutional rights, I'm thinking hearsay and Sixth Amendment Confrontation Clause. So I would kind of like immediately write that down, kind of mark it as an issue. When we see, is the caller statements to the police dispatcher inadmissible hearsay? And then the next question asks whether there could be a constitutional right violation with those same statements. The thing that goes hand in hand with hearsay and constitutional right violations would be hearsay in the Sixth Amendment Confrontation Clause for the reasons we laid out earlier, right? How do we reconcile the fact that these out-of-court statements can come into court and the declarant who made the out-of-court statement is unavailable, right? How does the defendant cross-examine somebody who's unavailable? If they can't, isn't that a violation of the Confrontation Clause, right? The guarantee that a person accused of a crime has the right to confront witnesses against him, right? And this is what the Confrontation Clause kind of explores. And actually, this was a tough issue, right? This was grappled with for like 20, 30 years. In law school, you'll spend a lot of time reading all these court decisions from the Supreme Court, kind of grappling with this idea. Now, today, it's easy, right? Because we get in 2004 kind of a black and white test, right? We get this idea, well, if the statements are testimonial, right? A statement is testimonial if the declarant would reasonably expect that the statement would be used for prosecution purposes, right? If the statement is testimonial, then it is a violation of the Sixth Amendment right to confront witnesses against him, right? So the use of an out-of-court statement, even if it falls under a valid hearsay exception, violates the defendant's constitutional rights under the Sixth Amendment if the statement is testimonial, right? So that's what we're really going to be looking out for with these statements, right? The caller's statements to the police dispatcher and the officer's testimony repeating the sister's statements. A big question with these statements when we're thinking about whether there's a potential constitutional right violation under the Confrontation Clause is going to be whether these statements are testimonial, right? And remember, a statement is testimonial if the declarant would reasonably expect that the statement would be used for prosecution purposes. And it does look like the statements are going to be made to police. So a common issue is whether statements made to police would be used for prosecution purposes or not. A lot of times this is going to come down to what the primary purpose is behind the statements. Is it about the collection of evidence? Is it about collecting evidence, basically like investigating a crime? Or is it to provide assistance in an ongoing emergency? Assistance in an ongoing emergency. Right? If it's to provide assistance in an ongoing emergency, because look, we see a call, right? The caller's statements to the police dispatcher, right? If those statements are being made to provide assistance in an ongoing emergency, which my instinct is that's probably what's going on. That's generally why people call 911. There's an emergency and they're like, hey, I need help, right? So if that's what those statements are, right, to provide assistance in an ongoing emergency, then those statements are not testimonial, right? And so those statements are not going to violate the Sixth Amendment Confrontation Clause because they're not testimonial. If, however, the statements are made for the primary purpose of collection of evidence to be used in a future criminal prosecution, then the statements will be testimonial and barred as a violation of the Sixth Amendment Confrontation Clause. So as we read these statements in the fact pattern, and we're thinking about B and D, whether there's constitutional rights violations, the biggest question we're going to have is whether the statements made to police have a primary purpose as to collection of evidence or assistance in an ongoing emergency. And that's really going to give us our answer we're looking for as to whether there is a constitutional violation under the Confrontation Clause or not. So that should actually be B and D should be relatively straightforward analyses. Confrontation Clause has actually become a pretty easy analysis. It just comes down to whether the statements are testimonial or not testimonial. Before 2004 in Crawford v. Washington, we had all these subjective tests. Things were more difficult, but the Supreme Court has really made this kind of more of like a bright line rule, and it just comes down to whether the statements are testimonial. If the statements are testimonial, it's going to be a violation of the Sixth Amendment Confrontation Clause. If they're not testimonial, then there's no violation. And when we're thinking about statements made to police, this is a very common issue with the Confrontation Clause. That usually comes down to whether the statements are made for the purpose of collection of evidence or assistance in an ongoing emergency. This would be not testimonial. This would be testimonial. right? So not testimonial would be no violation. This would be a violation of the Sixth Amendment. So that's what we're going to look out for. All a very long-winded way of saying kind of what we're looking out for in terms of constitutional violations as we read the fact pattern. So on top of this, though, we also know we're going to have some just standard hearsay analyses, right? So it looks like we're going to have, as major issues, because that's what we're trying to do here is we read the call of the question. We're trying to kind of identify from this call of the question what our major issues are. So we think a major issue is going to be the Sixth Amendment Confrontation Clause, because this is just the major evidence issue that's interwoven with a hearsay analysis. So I, in my head, kind of know already how this fact pattern is probably going to look before I even read it. Right? It's going to be a situation where we have these out of court statements being made, and then the declarant is going to be unavailable to testify at trial. And that's what gives us our confrontation clause problem, right? Anytime we have out of court statements coming into court and the person who made those statements is unavailable for cross-examination, well, that's a problem for the defendant, because the defendant under the Sixth Amendment has a guaranteed right to cross-examine his accusers. That's the confrontation clause. So that's kind of how we know this is probably going to be a major issue. And we'll want to identify, right, to trigger the confrontation clause. By the way, this only applies to criminal actions. So we do need to verify that it is a criminal action, that the declarants are actually unavailable to be cross-examined at trial, and that the defendant didn't have some opportunity earlier to cross-examine the declarant. Right. And then we'll make sure once those three things are satisfied, we know that's really what triggers the confrontation clause analysis. But I'm imagining, based on the structure of this call of the question, that that's what's going to happen. It's going to be a criminal action. Our declarants are going to be unavailable. And we're going to see that the defendant never had the opportunity to cross-examine the declarants. And that's what's going to trigger the confrontation clause analysis. And the major issue is going to be whether the statements are testimonial or not testimonial. So that's how I'm imagining that analysis is going to go, just based on the structure of this, where we have hearsay, and then it's asking, when we're looking at the call of the question, and we see, okay, we have a hearsay analysis, and then a constitutional right analysis, another hearsay analysis, another constitutional right analysis. That's really what's leading me to believe, okay, we're going to have some major Sixth Amendment confrontation clause issues. Okay. But again, we'll flesh this out more as we read the call of the question. Of course, though, in addition to the confrontation clause analysis, we know we're going to have to just do some standard hearsay analyses, right? And hearsay, we know, is a three-step analysis. I always say when we're doing a hearsay analysis, and that's what it looks like A and C are going to be. Remember, A asks, whether the caller's statements to the police dispatcher are inadmissible hearsay. And question C kind of says the same thing, whether the officer's testimony repeating the sister's statements is inadmissible hearsay. Well, to make this determination on A and C, it's going to be three steps for each one. Number one, right, step one with our hearsay analyses is always going to be, is it hearsay? Is it hearsay, right? And this is FRE Rule 801C of the Federal Rules of Evidence, right? This is step one of our hearsay analysis. We always want to ask, well, is it hearsay? What is hearsay? And really, we should think about this in terms of three elements, right? We're looking for an out of court statement that's being offered to prove the truth of the matter asserted in that statement. If those three elements are satisfied, that's 801C, we say, okay, our starting point rule is going to be, it's probably hearsay. If we have an out-of-court statement that's being offered to prove the truth of the matter asserted, our starting point rule is, okay, it is hearsay. But step number two, we have to do a quick check on this. Step number two, I like to phrase this as, okay, step one is it hearsay? Step two is going to be, is it not hearsay? Is it not hearsay? And this is 801D. 801D, right? We're thinking about the federal rules. Rule 801D kind of lays out some categorical criteria. And if that categorical criteria is satisfied, then we say, even if it is an out-of-court statement that's being offered to prove the truth of the matter asserted, because it meets this 801D criteria, it's actually not hearsay, right? And this would be prior consistent statements, prior inconsistent statements, prior statements of identification, and an opposing party's statements offered against the opposing party. So step number 2, we're always looking out for the situation where the declarant is the witness, right? There's 2 kind of triggering factors for 801D, right? When we're thinking about whether 801D is triggered. We have 801D1 and we have 801D2, right? 801D1 would be the situation where the declarant is the witness, right? So we can just say declarant is the witness. This would be the situation where we have a person who makes an out-of-court statement, right? So that would be the declarant. The person who's making the out-of-court statement actually comes into court and testifies to their own statements, right? That would make them a declarant witness, right? The declarant is the witness testifying at trial. This is where we can get into things like prior inconsistent statements, prior consistent statements, and prior statements of identification, where the declarant says something out of court, then they come into court, now they're the witness, and they either make inconsistent statements, consistent statements, or statements of identification, right? That could all trigger 801D1 issues. 801D2 is easy. This is just statements of an opposing party. If we see that a party to the action is actually the declarant, right? The person who's making the out-of-court statements is a party to the action, we have to think about 801D2. Classically, this would be like the defendant making a confession to the police, right? Well, that's an out-of-court statement, but it's a statement of an opposing party, right? Statements of an opposing party offered against the opposing party are not hearsay. Most classically, this would be like a confession from the defendant to the police officer. That's an out-of-court statement that's being offered to prove the truth of the matter asserted, but it's an opposing party statement offered against the opposing party by the prosecution, so it's not hearsay under 801D2. So 801D2 really gets triggered when the declarant is a party to the action. Okay, so those are what we'd want to look out for. If the declarant is a witness or the declarant is a party to the action, we have to think about 801D. Now, based on this call of the question, it looks like we have number 1, if we think about the officers, if we're looking at A and C, it looks like at least for C, a police officer is repeating the sister's statements, right? So we know for that one, the declarant is not the witness. So 801D1 is not triggered. And we know here that the caller's statements to the police and the sister's statements to police are probably, we know the caller and the sister are probably not the defendant here. The caller and the sister are likely not the defendant. It looks like the boyfriend is the person who the defendant's going to be, because that's who's asking whether the boyfriend's constitutional rights have been violated. So the caller and the sister are likely the victims here. They are not going to be our actual party to the lawsuit. So it does look like to me 801D2 is probably off the table. And I'm imagining, right, in order to make the confrontation clause analysis work, the declarants are going to have to be unavailable. So my guess is the declarants cannot also be the witnesses, or we couldn't then have a confrontation clause analysis. So to make this fact pattern work, step number 2 is probably all going to be off the table, right? Because we can't have a declarant who is a witness. Otherwise, we wouldn't have confrontation clause issues, right? If the declarant shows up and is the witness, then they're subject to cross-examination. We can't have the confrontation clause triggered. So that would take 801D1 off the table. And 801D2, the caller and the sister are not parties to the suit. So 801D2 is probably off. My guess is we don't even have to worry about step 2 in this analysis. Now, of course, we have to see what's actually happening, but that's just my instinct as I read this. Okay, which takes us to step number 3. Right after we go through 801C and 801D, step number 3 is going to be exceptions, right? Exceptions to the hearsay rule. And this is going to be rules 803 through 804 of the Federal Rules of Evidence. Rule 803, the declarant availability is irrelevant. Rule 804, we know for those to apply, the declarant must be unavailable. Now, my guess again here is that our declarants are both going to be unavailable. So that means all of these exceptions are potentially on the table, right? 803, we're always thinking about the acronym I use is PET Mr. B. So we have PET Mr. B. Sorry, running out of room here, which would be present sense impression, excited utterance, then existing mental, emotional, or physical condition, statements made for medical diagnosis or treatment, recorded recollection, business records exception. 804, these you just need to memorize. This would be things like former testimony, dying declaration, statement against interest, forfeiture by wrongdoing. And again, the idea here is with the exceptions, right? Even if we have a statement being offered to prove the truth of the matter, right? The 801C requirements are met. We have an out-of-court statement that's being offered to prove the truth of the matter asserted. None of the 801D criteria is met, so it is hearsay. The only way it can come into court is through an exception, 803 and 804. Okay, and these, again, we just kind of have to have them all memorized. There's actually like a couple dozen exceptions there, but these would be the most commonly tested, kind of present sense impression, excited utterance, then existing mental, emotional, or physical conditions, statements made for medical diagnosis or treatment, recorded recollection, business records. Those would be our kind of 803 exceptions where we say whether the declarant is available or not is immaterial. And then we have 804 exceptions. The big difference there is in order for those exceptions to be satisfied, the declarant must be unavailable, which is probably going to be the case in this fact pattern. Otherwise, the confrontation clause would not be triggered. These exceptions would be former testimony, dying declarations, statements against interest, and forfeiture by wrongdoing. So as we read the fact pattern, of course, we want to verify whether these statements being made, because we see an A and C in the call of the question, it looks like we're going to have statements made to police. We want to see, are these statements out of court? Are they actual statements, right? Remember, a statement as defined under 801C for hearsay purposes is an assertion that is made by a human being. This could be oral assertions, written assertions, or even nonverbal conduct if the person intended that conduct to be an assertion. So we'll want to make sure that we do have out-of-court statements that are being offered to prove the truth of the matter asserted in those statements. Okay, so that'll be step number 1. Step number 2 will be 801D, right? And we'll make sure, again, that the declarant is not the witness. If the declarant is the witness, right, the person who makes the out-of-court statement comes to court, and then we have prior consistent statements, prior inconsistent statements, or prior statements of identification, that could trigger 801D1, and those statements might not be hearsay under 801D1. We also have to think about 801D2 if the caller or the sister here are actually the defendant. But we don't think that's going to happen because that could be an opposing party's statements offered against the opposing party, which is not hearsay. That's 801D2. But again, we don't think the 801D exceptions or the 801D exclusions are going to be satisfied here. It doesn't look like our declarants are going to be available at trial. So that takes 801D1 off the table. And it looks like neither the caller, the person who's making these statements, the caller or the sister is going to be an actual party to the action. It looks like the boyfriend is going to be the defendant. So we don't have to worry about 801D2. So it looks like we're really going to be focused on step number 1, 801C, and then we're going to be thinking about exceptions. Okay, so is it hearsay? Are those 3 elements satisfied? Do we have an out-of-court statement being offered to prove the truth of the matter asserted in that statement? If so, is there an exception? Then we know, okay, it's hearsay. Step number 3 will be, is there an exception that would allow those statements to come into court, right? And that would be 803 and 804. And then we're going to see, okay, if we do have a situation where we have an out-of-court statement coming into court and the declarant is unavailable to testify, well, is that a violation of the defendant's Sixth Amendment right to confront his accusers, to cross-examine his accusers? And that will come down to whether the statements are testimonial or not testimonial. Okay, so that's the big picture overview here with this evidence essay. That's what I really think this analysis is going to look like based on this call of the question. But with that, I think we've identified all of the kind of major issues that we're going to encounter on this essay. From here, we're ready to begin actually reading the fact pattern, starting with paragraph number 1. Paragraph number 1 tells us that the city police department received a 911 call regarding a domestic violence incident. The caller said that she was staying with her sister and her sister's boyfriend. The caller said that she had called the police because her sister's boyfriend was becoming violent. The police department recorded all 911 calls. The relevant portions of the 911 call, of the 911 recording, are as follows. Okay, so it does look like the call is going to be recorded, right? Anytime we have a recorded phone call, another issue that this could raise is going to be authentication, right? Anytime we have evidence that's tangible that the jurors could hold in their hands, like a recording of a phone call, that has to be authenticated. So we'll see as we read on whether there could be an issue with authentication, whether the evidence is what the proponent claims it to be as we kind of read on. But just as a note, anytime we see a recording, text messages, faxes, statements that are basically fixed to tangible mediums, recordings, text messages, faxes, written statements, that all is going to potentially trigger authentication as an issue. Now, I didn't see authentication when we're kind of looking at the actual objections. So my guess is we don't have to worry about it, but just when I see recording of a phone call, my brain instantly thinks authentication. But remembering back to what the actual objections were, we don't see anything about authentication. So my guess is we don't have to worry about it. But just when I see the word recording, especially like a phone call, I just instantly think in an evidence essay, authentication. Okay, other notable facts from this first paragraph would be the facts that this does look like we have an emergency situation brewing. And remember, when we're thinking about whether statements coming into court are going to be a violation of the defendant's Sixth Amendment right to confront witnesses, right? This confrontation clause under the Sixth Amendment, it's going to come down to usually whether the statements are testimonial or not testimonial, which usually comes down to, if we're talking about statements made to police, whether the statements are made for the primary purpose of collection of evidence or the primary purpose of assistance in an emergency situation, an ongoing emergency. So it looks to me like if we have a 911 call where a person is becoming violent in this domestic violence incident, the purpose of this call is probably more going to be about assistance in an ongoing emergency. And this is going to go to whether these statements we're about to see from the caller are testimonial or not testimonial. But we need to identify, when does this emergency situation end, right? That's now going to be an important fact. Basically, when is this suspect, this person who's becoming violent, when is he ultimately subdued in this fact pattern? Are we going to see him placed in handcuffs and, seized and stowed away somewhere? And then once that emergency situation ends, statements made after that point, that could be different. That might be when we get to collection of evidence. Okay, but we have to read on to see. And all of this, by the way, goes to the Sixth Amendment Confrontation Clause issues. We also have to think about hearsay. We know all of these. We need to look at, are these out-of-court statements being offered to prove the truth of the matter asserted? That's going to be step one in our hearsay analysis for A and C, those objections. Okay, but we can keep reading. Let's see what the actual statements, these out-of-court statements made by the caller, are actually going to be. So here we see that the caller says, my sister's boyfriend is out of control right now. He just threw a broken beer bottle at my sister. It hit her on the arm. Now he's holding a chair like he's going to throw that at her too. The police dispatcher asks, where is your sister? The caller responds, she's running toward the bathroom. The police dispatcher asks, is she injured? Caller responds, I see some blood on her arm. Police dispatcher asks again, does he have a gun? The caller responds, I don't see a gun. Okay, so we have a lot of out-of-court statements here. The question is going to be whether these statements are being offered to prove the truth of the matter asserted when we're thinking about step one in our hearsay analysis, right? But it does look like these are clearly out of court. These statements are being made outside the four corners of the courtroom. They're clearly out of court. They do appear to be statements. These are all assertions that are being made by a human being. When we look at what the caller is saying, right? All of the caller's statements are assertions, right? These are all statements. These are verbal assertions being made to the police dispatcher. Interestingly, all of the police dispatcher's questions, where is your sister? Is she injured? Does he have a gun? None of that is hearsay because they're questions. Questions are not assertions for hearsay purposes. A question seeks an assertion, but questions by themselves, unaccompanied by nonverbal conduct, are usually not hearsay because they're not assertions. So the police dispatcher's statements here would not be inadmissible hearsay because they just appear to be questions, which are not assertions. But we don't care about that because we're asking whether the caller's statements, remember, A asks us, are the caller's statements to the police dispatcher inadmissible hearsay? So they do appear to be assertions. All of these are sentences. They are assertions, right? They're made out of court. So it does look like elements 1 and 2 are going to be satisfied of 801C. Now we have to see why these statements are being introduced. Are they being introduced to prove the truth of the matter asserted in those statements, or could they be offered for some other reason, to show the effect on the listener, to show the declarant's mental state, to potentially impeach a witness? Are they verbal acts of independent legal significance? Right, so we'd want to look out for some things to make sure. We need to see basically why does the proponent of these statements, these evidentiary statements, why are these statements being introduced? Is it to prove the truth of the matter asserted in those statements or potentially some other reason? Okay, but that'll be our step 1 in our hearsay analysis. As far as potential exceptions with these statements, a lot of exceptions come to mind, right? Anytime we're thinking about a 911 call where a person is describing an emergency as it's happening, that is basically the definition of present sense impression. Present sense impressions are going to be a statement describing or explaining an event or condition made while or immediately after the declarant perceived it. So our caller here describing what is happening as she's perceiving it, right? She's saying, my sister's boyfriend is out of control right now. He just threw a broken beer bottle at my sister. She appears to be describing events and conditions as they are happening. So that's going to all be present sense impressions, right? So even if we have an out-of-court statement that's being offered to prove the truth of the matter asserted, it does look like those will be able to come in under the present sense impression exception. Additionally, right, if this is like a startling event, right, this domestic violence situation, that could also be excited utterance, right? A statement relating to a startling event or condition made while the declarant was under the stress of excitement that it caused. which appears to kind of be the situation here with this emergency situation. These statements that the caller is making could potentially be excited utterances. I don't like that as much as present sense impression, but it is something we would want to bring up in our essay. And it's really going to come down to whether she's still under the stress of excitement of this startling event. We'll have to see kind of more facts. Is she still under that stress? If so, they could be excited utterances. Additionally, we do see the police dispatcher is asking whether a person is injured. The statements that relate to the injury itself. This one right here, I see some blood on her arm. Potentially, that could be that statement by itself right here. I see some blood on her arm. Could be a statement made for medical diagnosis or treatment, right? We know a statement that is made for medical diagnosis or treatment and describes medical history, past or present symptoms or sensations, their inceptions or their general cause, right? These types of statements made for medical diagnosis or treatment could be an exception to the hearsay rule that allow these out-of-court statements to come into court, even if they're being offered to prove the truth of the matter asserted in those statements. So in terms of exceptions I'm seeing for the caller, we have present sense impression, we have excited utterance, and statements made for medical diagnosis or treatment where she's responding to the police dispatcher, is she injured? I see some blood on her arm. That statement could be a statement made for medical diagnosis or treatment, but all of the statements look like present sense impressions and maybe even excited utterances. So these for sure, I'm discussing for all of the statements, and this response about the blood on her arm could be medical diagnosis or treatment when we're thinking about the exceptions. Okay, so those are all the major issues I'm seeing with the statements from the caller to the police dispatcher. Now, we still need to know, why are these statements being introduced, right? Are they being introduced to prove the truth of the matter asserted in those statements, or for some other reason? We'll only know that by reading on, which takes us to the next paragraph. The next paragraph tells us that a nearby police officer arrived on the scene 5 minutes after the caller telephoned 911. The police officer found the boyfriend pacing in the front yard and ordered him to sit in the rear seat of the patrol car. The boyfriend sat in the patrol car, and the officer locked the door from the outside so that the boyfriend would stay in the car while the officer spoke to the sister. So to me, this paragraph really sets up the fact that the emergency is subsiding. Remember, when we're thinking about our analysis of the confrontation clause and whether statements are being made for the purpose of collecting evidence or for the purpose of assistance in an ongoing emergency, which is going to tell us whether the statements are testimonial or not testimonial, which tells us whether there's a violation of the confrontation clause or not. This is where the situation as to whether the emergency is ongoing or not becomes very important, right? And it does look like at this point in time, the emergency situation is ending. So we can just be like, emergency situation ending. So probably the statements that are now going to be made from the sister to the police officer at the scene, it looks like these are primarily going to be made for the purpose of collecting evidence because the emergency situation is over, right? There's no need to provide more assistance here. This is probably now going to be about collecting evidence for the prosecution of the boyfriend. And so these statements are probably going to be testimonial. Any statements made for, remember, we said these statements, the actual 911 call, these statements look like the primary purpose is to provide assistance in an ongoing emergency. But then it looks like the emergency situation ends, and now the sister is going to talk to the police officer for the purpose of collecting evidence to use against the boyfriend in his upcoming criminal prosecution. So these statements probably are going to be testimonial, and this is where we could actually get a violation of the confrontation clause if the sister is unavailable to testify and these out-of-court statements are coming in and she's not available and they're testimonial, right? Well, if he can't cross-examine her, that could be a violation of the boyfriend's Sixth Amendment right to confront his accusers. So that's where we're going to get into the constitutional violations for these statements made from the sister to the police officer. Okay, but we have to keep reading. The next paragraph tells us that when the sister saw that her boyfriend was locked in the patrol car, she came out on the porch to speak with the officer. The sister was in a highly agitated and emotional state. Okay, anytime we see highly agitated and emotional state, I'm thinking about excited utterances. And she, reading on, the sister was in a highly agitated and emotional state, and she had several fresh cuts on her right arm. The officer asked her how she got the cuts. The sister replied, "My boyfriend threw a bottle at me, which cut my arm." The sister declined the officer's offer of medical assistance. That's important. The sister declined the officer's offer of medical assistance. So that probably takes a statement made for medical diagnosis or treatment off the table for these statements, but said that she wanted to press charges against her boyfriend. The sister was in tears throughout the conversation with the officer. Okay, so this is really setting up like excited utterance, was in tears throughout the conversation. So this paragraph really makes it seem like, okay, the sister's statements to the police officer at the scene are going to be out of court verbal assertions. So clearly they're out of court statements. It's going to satisfy these two elements. Right, we'll have to see why these statements are being introduced. Are they being introduced to prove the truth of the matter asserted in those statements? But even if they are, it looks like even if these statements end up being hearsay, they're out-of-court statements being offered to prove the truth of the matter asserted, they'll be able to come in under the excited utterance exception. Right, because she's in this highly agitated, emotional state. When she's talking to the police officer, we know a statement relating to a startling event or condition made while the declarant was under the stress of excitement that it caused is an excited utterance. And we know excited utterances can come in even if they're out-of-court statements being offered to prove the truth of the matter asserted, as an exception to the hearsay rule. So this paragraph really sets up like an excited utterance analysis. Okay, but we have to keep reading. I mean, the big facts we're still looking out for is why are these statements being introduced? Are they being introduced to prove the truth of the matter asserted in the statements or for some other reason? Because that's kind of the last element of our 801C analysis in determining whether the statements are hearsay. So we have to keep reading, and we're really looking out for why is the proponent of these statements, these pieces of evidence, introducing these pieces of evidence. Okay, but we have to keep reading. Next paragraph tells us that the boyfriend was charged in state court with battery and disorderly conduct. The prosecutor made every effort to secure the appearance of both the sister and the caller at trial, but when the trial began, the sister and the caller did not appear. Okay, this is a huge fact, right? This lets us know that the declarants, the people who made the statements out of court, are now unavailable to testify at the trial. So this is like the big triggering event of the Sixth Amendment Confrontation Clause. This was very predictable, again, just based on the structure of the call of the question, where we see, okay, do a hearsay analysis and then talk about potential constitutional rights that were violated, do another hearsay analysis and talk about potential constitutional rights that were violated. To me, that was a really big indicator that we're going to have hearsay and then a confrontation clause analysis, hearsay and another confrontation clause analysis, just because that's the only constitutional right that's really interwoven with a hearsay analysis. Okay, but this is the fact that ultimately for sure triggers the Sixth Amendment Confrontation Clause, right? We know now that the proceeding is a criminal action, not a civil action. Confrontation Clause would not apply to civil actions, but we see that we actually have a prosecutor charging the boyfriend with battery and disorderly conduct as crimes. So, okay, the proceeding is a criminal action, not a civil action. We see that the declarants are unavailable to be cross-examined at trial, And it doesn't look like the defendant had an opportunity to cross-examine the declarant at a proceeding prior to trial. So now the only question left is going to be whether the out-of-court statements are testimonial or not testimonial. So this paragraph really is what lets you know we are for sure discussing the Confrontation Clause. It gives us the additional facts. It is a criminal action. We know the Confrontation Clause only applies to criminal defendants, right? Not civil action. So, okay, it is a criminal trial. We see the declarants are unavailable to be cross-examined. It doesn't look like we have any prior proceedings where the defendant would have had some opportunity to cross-examine the declarants. So now we know, okay, Confrontation Clause is triggered. The main issue is going to be whether the statements were testimonial or not testimonial. And because the statements were made to police, that really comes down to whether the statements were made for the purpose of collecting evidence or for the providing of assistance in an ongoing emergency. We've kind of identified probably the 911 call was about providing assistance in an ongoing emergency. But then we saw the emergency situation ended, boyfriend was subdued, and then we see these additional statements being made that look more so about the collection of evidence to be used against the boyfriend in his criminal trial. Those statements probably are testimonial, and that's probably now where we're going to get a violation of his Sixth Amendment Confrontation Clause right, guarantee to confront the people that are accusing him of the crime. Okay, but we have to keep going. Still, to me, a big fact we're looking out for is why are these pieces of evidence being introduced? Why are these statements coming in? Are they coming in to prove the truth of the matter asserted in the statements or some other reason? So we're going to get to that eventually, probably this paragraph, but let's keep reading. This paragraph, the next paragraph, tells us that the prosecutor is attempting to convict the boyfriend without trial testimony from the sister or the caller. The prosecutor plans to introduce the caller's statements to the police dispatcher and to call the officer to testify and to repeat the statements the sister made to him at her house to prove that the boyfriend attacked the sister. Okay, so all of these out-of-court statements are being offered to prove that the boyfriend attacked the sister, right? That basically now gives us this third element to prove the truth of the matter asserted in these statements. These statements, the substantive purpose really behind all of these statements is to prove that the boyfriend is guilty of these crimes, that the boyfriend attacked the sister. I mean, that's the main idea behind these statements. That's to prove the truth of the matter asserted in these statements. That's the substantive issue at trial we're trying to determine, the guilt of the criminal defendant. So offering these statements to prove that this defendant is guilty, that the boyfriend attacked the sister, is really offering these statements to prove the truth of the matter asserted. You're not offering the statements for some other reason, to show the effect on the listener. We're not offering these statements to show what the effect was on the police officer or the 911 dispatcher. We're not offering these statements to show what the declarant's mental state is, right? It tells us we're offering to prove that the boyfriend attacked the sister. So it's not offering the statements to prove maybe what the declarant's mental state was. You're not offering these statements for impeachment purpose. The statements don't have any independent legal significance, like defamatory statements or bribes or threats. We're not seeing any of that. We're offering the statements. The prosecution wants to offer the statements to prove that the boyfriend is basically guilty, which is like the ultimate substantive reason to introduce out-of-court statements in a criminal trial. Therefore, we know that likely these statements are being introduced to prove the truth of the matter asserted in the statements. So that tells us that these statements are all going to be out-of-court statements offered to prove the truth of the matter asserted under 801C. We're confident they're hearsay. Remember, we'd always want to, step number 2, run through 801D really quick. After we go through 801C, we always do a check on 801D, right? But 801D isn't really triggered here Again, and we talked about this earlier, 801D1 would be prior consistent statements, prior inconsistent statements, and prior statements of identification. But we know these are not triggered because the declarants who made the out-of-court statements are unavailable to testify at trial. So we can't have prior consistent statements, prior inconsistent statements, prior consistent statements. To trigger 801D1, the declarant has to be the witness, meaning the person who made the out-of-court statement has to actually come into court to testify to those out-of-court statements, which is not happening here. It's the opposite. The out-of-court person, right, the person who made the out-of-court statement, the declarant, is unavailable to testify. So that takes 801D1 off the table. And 801D2, remember, in a criminal context, would usually be like confessions made by the defendant. This would be an opposing party's statements offered against the opposing party. Here, neither the caller or the sister are parties to the action, so 801D2 is off the table. So we don't have to worry about 801D in this analysis. We're just step 1 and step 3. 801C looks to be satisfied. We have out-of-court statements being offered to prove the truth of the matter asserted, so we know the only way these statements can now come into court is through an exception under Rules 803 and 804. And remember, we talked about a lot of possibilities here. You could have present sense impression, excited utterance, maybe statements made for medical diagnosis or treatment. We'll go through that when we get to those analyses. But that kind of looks like the big picture as to what's going on. Which takes us to our last paragraph here before we get back to the call of the question. The last paragraph tells us that the 911 recording containing the caller's statements to the police dispatcher has been properly authenticated. Okay, so that's a nice fact to get. We wouldn't have talked about that anyways because the defense counsel doesn't object to it. Remember, we get these really specific objections in A, B, C, and D. We get these really specific objections, and there was nothing about authentication there, so we probably didn't have to discuss it. But remember, I think I did mention earlier, anytime we see, a recorded phone call, as I noted, we would want to think about authentication. So I think this fact right here telling you that the recording has been properly authenticated, basically it is what the proponent of the evidence claims it to be. It hasn't been doctored in any way that would make it inauthentic, right? It's just telling you that so you don't accidentally discuss authentication here. It's not an issue they're looking for. So that's a good fact to get. Next, it tells us that defense counsel has objected to the admission of, number 1, the caller's statements to the police dispatcher on the 911 recording, and number 2, the officer's testimony repeating the sister's statement to the officer at her house. We knew all of that. Defense counsel asserts the following. We've already gone through that. We're applying the federal rules of evidence and United States Supreme Court precedent, which would basically be Sixth Amendment Confrontation Clause. The major case here, bonus points for citing this. You wouldn't have to get full points, but the case is Crawford v. Washington. This is really what gives us the test that we're going to use here in determining whether these statements are testimonial or not testimonial. But okay, for purposes of the Confrontation Clause analysis. And then it asks, finally, how should the trial court rule on each defense objection? Explain. Okay, well, I think we've identified all the main issues here. We can just go point by point and see what the bar examiners were looking for and kind of break this down objection by objection, starting with number A, or objection A, which was whether the caller's statements to the police dispatcher are inadmissible hearsay, right? Which was point number 1, which was worth 20% of this essay. Here, the bar examiners were looking for examinees to conclude that if offered to prove the truth of the matter asserted, that the boyfriend attacked the sister, the caller's statements to the police dispatcher are hearsay. However, her statements fit the hearsay exceptions for present sense impressions and excited utterances and probably fit the exception for statements made for purposes of medical diagnosis. Okay, great. Yeah, this is mostly what we talked about. So remember, here we're talking about these statements. the statements that the caller makes to the police dispatcher. So step number one, we always start with, a hearsay analysis, 801C. And remember, we have those three elements. Question number one is always, is it hearsay? Well, is it an out of court statement being offered to prove the truth of the matter asserted in that statement? If so, we say it's hearsay, right? Remember, we always have to think about 801D, but I'm not going to talk about 801D here because we've talked about it ad nauseum. We know why 801D is not triggered. So we go 801C, and then we have to think about exceptions under 803 and 804. Okay, but we can start with 801C. Do we have out-of-court statements being offered to prove the truth of the matter asserted? And the answer is obviously yes here. Remember, the statements are being made outside the four corners of the courtroom, right? This 911 call is happening out of court. It's full of, the caller's statements at least are verbal, oral assertions. They're all statements. They're assertive in nature. We don't have any questions being asked here, right? The police dispatcher asks questions. Remember, those are not assertions, so they're not hearsay, but we're not asking whether the police dispatcher's statements are hearsay or not hearsay. We're asking whether the caller's statements are hearsay. And they do appear to be very clear assertions. We have oral assertions. So, okay, we have out-of-court statements. And remember, they are offered to prove the truth of the matter asserted. It told us that down here, that the prosecution wants to introduce these statements to prove that the boyfriend attacked the sister. We're not offering these statements to show the effect on the 911 dispatcher. We're not offering them to show, what the caller's mental state or state of mind was. We're not offering them to impeach a witness. They don't have verbal, they're not verbal acts of independent legal significance like defamatory statements, bribes, or threats. Right? We're introducing these statements for substantive purposes to prove the guilt of the defendant. So we do have out-of-court statements being offered to prove the truth of the matter asserted. That's how we got to, okay, these statements are hearsay, but that's not the end of the analysis. We go to 803 through 804, and we think about possible exceptions. And we talked about this as we read it. Here we have present sense impressions, excited utterances, and maybe statements made for medical diagnosis, which is statements made for medical diagnosis or treatment. That's kind of how I would write that, but I take what the bar examiners mean, right? Okay, so here though, definitely, and usually, when we're thinking about a 911 call where a person is describing what they are seeing as the event is unfolding, that's almost always going to be present sense impressions. Remember, under the federal rules of evidence, a statement describing or explaining an event or condition made while or immediately after the declarant perceived it is going to constitute a present sense impression. And present sense impressions can come in even to prove the truth of the matter asserted in those statements. It's just an exception to the hearsay rule. So this was definitely a present sense impression. All of these statements are present sense impressions, right? They're statements that are describing an event while the declarant is perceiving it, right? Key words would be, my sister's boyfriend is out of control right now, right? Describing it as she's seeing it. He just threw a broken beer bottle at my sister. It hit her on the arm. Now he's holding a chair, right? So she's describing all these words, things like now he's holding a chair, like he's going to throw that at her too. Where is your sister? She's running toward the bathroom, right? All of these words I would use to show that the declarant, our caller, is actually describing the event as she's perceiving it. So these are present sense impressions. They're admissible. Even if they're out-of-court statements being offered to prove the truth of the matter asserted, they're admissible under the exception to the hearsay rule as present sense impressions. Okay, so I agree with that right here. Could also be excited utterances. We know a excited utterance under the federal rules of evidence is going to be a statement relating to a startling event or condition made while the declarant was under the stress of excitement that it caused. Here, it does seem she's describing something as it's happening, right? It's obviously a very startling event. We have a domestic violence incident unfolding, right? I imagine most people who are watching, a loved one that is in a domestic violence incident is going to be under stress and excitement of that event. So statements relating to that event made while under the stress of the event are excited utterances. So yeah, I think that would be satisfied here, right? It does seem like, this is going to be a startling event and the declarant is under the stress of that event as she's making the statements. Therefore, yes, probably excited utterances. I would have liked to have gotten a fact that she was, stressed or nervous or excited, that would have helped this analysis. But, we can just make the basic assumption here. If you're witnessing a loved one, right, that's going under something like this, they're going to be, the declarant who's making the statements is going to be, very excited, very startled, very stressed out under the stress of excitement that's caused by this domestic violence. So yes, I get excited utterance. And the bar examiners also said, probably fit the exception for statements made for purposes of medical diagnosis or treatment. I would agree with that on this statement, right? Where we have the caller saying, I see some blood on her arm. Police dispatcher asks, is she injured? And the response is, I see some blood on her arm. Yeah, that's a statement made for the purpose of medical diagnosis or treatment. And it's clearly describing past or present symptoms and their inception and general cause, right? We know the official definition of a statement made for medical diagnosis or treatment as an exception under the federal rules of evidence is a statement that's made for the purpose of medical diagnosis or treatment and describes either the medical history, past or present symptoms, their inception, or their general cause. Well, this is clearly describing present symptoms, right? Blood on her arm, and that's being made for the purpose of medical diagnosis. So this dispatcher knows, hey, what am I telling the ambulance when they get there? So it does seem like, yes, that statement's probably also a statement made for medical diagnosis or treatment. So that was point number 1, worth 20% of this essay, which takes us to point number 2, which was worth 25% of the essay. Here, the bar examiners were looking for examinees to conclude that the Confrontation Clause does not bar the admission of an out-of-court statement when the objective primary purpose of the interrogation was to address an ongoing emergency. Okay, so this went to Objection B, whether admission of the caller's statements to the police dispatcher would violate the boyfriend's constitutional rights. So this was just a Confrontation Clause analysis. So kind of to help, right, your gateway issues here, just to give like official maybe elements to think about, right? We can think about a Confrontation Clause as having like kind of 3 trigger events. Number 1, to apply, we have to make sure that the proceeding is criminal. So I would make sure that the proceeding is criminal. Number 2, the declarant has to be unavailable. Number 3, right, the defendant couldn't have had an opportunity to cross-examine the declarant at a proceeding prior to the trial. So basically no prior opportunity to cross-examine. And finally, then our last question would be whether the statement is testimonial. So we can just say testimonial ? So this is kind of what your Confrontation Clause analysis should look like. The first 3 elements here I would think of as like trigger events. Well, the Confrontation Clause only applies to criminal proceedings. Here we have a criminal proceeding. Remember, the prosecutor is attempting to convict the boyfriend, right? So it's clearly a criminal proceeding. We were told that the declarants are both unavailable. The sister and the caller did not appear. So our declarants, the people who made the out-of-court statements, are unavailable. We see no prior proceeding here where the defendant would have had the opportunity to cross-examine these declarants. So there was no prior opportunity, right? So kind of all 3 gateway issues are satisfied. That triggers the Confrontation Clause. Think about it. We're bringing in an out-of-court statement, but the person who made that statement is not available, and the defendant has no opportunity to cross-examine this person, right? And we know the Sixth Amendment Confrontation Clause guarantees a person accused of a crime the right to confront witnesses against him in a criminal action. This includes the right to cross-examine the prosecution's witnesses. So the Supreme Court has told us, okay, well, if we have this situation where an out-of-court statement is coming into court, but the person who made that statement is unavailable to be cross-examined, whether that's a violation of the defendant's Sixth Amendment right to confront witnesses against him comes down to whether the statement is testimonial or not testimonial. And we say a statement is testimonial if the declarant would reasonably expect that the statement would be used for prosecution purposes. Now, in this type of fact pattern where we have statements made to the police, which is a really common confrontation clause fact pattern, it really comes down to whether the primary purpose of the statements is the collection of evidence or to provide assistance in an ongoing emergency. Right? If it's to provide assistance in an ongoing emergency, then it's not testimonial. If it's for the primary purpose of collecting evidence to be used in a future criminal prosecution, it is testimonial. And I think the key here was what the bar examiners are saying. The objective primary purpose of the interrogation was to address an ongoing emergency. So the statements were not testimonial. Therefore, there's no violation of the Confrontation Clause, meaning the Confrontation Clause does not bar the admission of the out-of-court statements made by the caller to the police dispatcher. And I mean, that should have been fairly intuitive here. When we have a 911 call where someone's, talking about what the situation is as it's unfolding to get help, right? The primary purpose of those statements is to seek assistance in an emergency, right? So that's what we had here. That's why the statements were not testimonial. That's why we don't have a violation of the Confrontation Clause. It was important to recognize that all three of these were satisfied as well. That's really what triggers the Confrontation Clause. We have a criminal action. The declarant is unavailable. We have an out-of-court statement made by the declarant coming into court, and the declarant is unavailable. And the defendant had no prior opportunity to cross-examine that declarant, well, we could have a violation of the Sixth Amendment Confrontation Clause. That comes down to, according to the Supreme Court, whether the statement is testimonial or not testimonial. Here, because it was to provide assistance in an ongoing emergency, it's not testimonial, no violation of the Confrontation Clause. That was point 2, 25% of the essay. Which takes us to point number 3, which is also worth 25% of the essay. Here, the bar examiners were looking for examinees to conclude that the sister's statements to the officer are hearsay if offered to prove the truth of the matter asserted, but fall under the excited utterance exception to the hearsay rule. Okay, so this is the same analysis as point number 1. With hearsay, we always start step 1 with 801C. Do we have, remember this is 3 elements, an out of court statement that is being offered to prove the truth of the matter asserted in that statement. If all 3 of these are met under 801C, we say, okay, it is hearsay. Remember, we would always step number 2, do a quick 801D check to make sure that it's not categorically excluded as non-hearsay. But remember, we talked about this ad nauseum at this point. 801D was not triggered. So here we would then jump straight to the exceptions, which are 803 and 804. But again, we start with step number 1, 801C. Do we have an out-of-court statement being offered to prove the truth of the matter asserted? And here we're talking about the sister statements to the officer, which happen down here, right, in this paragraph. And here we do see clearly, number 1, we are out of court, right? This is still at the scene of the crime. This is clearly out of court. We're outside the 4 corners of the courtroom, so we are out of court. And we see that the sister tells the officer, my boyfriend threw a bottle at me, which cut my arm. That's clearly an oral assertion, right? This isn't like a question. It's an oral assertion. So we do have an out-of-court statement, and we know it's being offered to prove the truth of the matter asserted. Remember, the prosecution is attempting to introduce all of this evidence to prove that the boyfriend attacked the sister. This is introducing the evidence for substantive purposes. Prosecution's not introducing this evidence for some other reason, like to show the effect on the listener. The prosecution's not introducing this statement that the boyfriend, where the sister says, my boyfriend threw a bottle at me, which cut my arm, to show the effect this had on the police officer. The prosecution's not introducing this to show the sister's mental state or state of mind. It's not being offered to impeach a witness. The statement doesn't have independent legal significance, like a defamatory statement or a bribe or a threat, something like that, right? It's just being offered to prove that the boyfriend did throw a bottle, which cut her, right? To prove that the defendant is guilty of this crime. So it's an out-of-court statement being offered to prove the truth of the matter asserted. That's why the bar examiner said the sister's statements to the officer are hearsay, right? And it is being offered to prove the truth of the matter asserted. That's given to us in the fact pattern. But, right, the bar examiners tell us this falls under the excited utterance exception to the hearsay rule. Remember, our analysis is 3 steps. It doesn't end when we go through these elements under 801C. We have to run through 801D because 801D could categorically exclude the statement as not hearsay. But we know 801D wasn't triggered. We talked about that ad nauseum. Not going to go through it again here. So we would just go to our exceptions and we'd run through all the exceptions. The one that was very, very clearly illustrated was excited utterance. We even marked that as we were reading it, right? So excited utterance was like clearly what was described here, where we see words like highly agitated and emotional state. The sister was highly agitated and in an emotional state. She had several fresh cuts on her arm, right? So when she's making the statement, she's clearly under the stress of the excitement that this startling event caused, right? So remember, an excited utterance is a statement relating to a startling event or condition made while the declarant was under the stress of excitement that it caused. That's clearly satisfied here, right? The statement relates to a startling event. The startling event would be the domestic violence incident. She's just been attacked by her boyfriend. So we have a startling event, and she's making the statement while under the stress of that startling event, right? It tells us she's highly agitated, emotional state. She's in tears throughout the whole conversation. I'd be using all of those facts in my essay when I'm describing the fact that the excited utterance exception to the hearsay rule is satisfied. Okay, so that was point number 3, 25%. There were no other exceptions we had to worry about here. I guess the reason we didn't have to discuss medical diagnosis or treatment is because the sister declined the officer's offer of medical assistance. So it's obviously not a statement being made for the purpose of medical diagnosis or treatment where she's declining the offer of medical assistance. Because I could see how maybe that looks like, she's describing a cut on her arm. That might look like a statement made for medical diagnosis or treatment, but because she declines the officer's offer of medical assistance, that's why we didn't have to discuss that exception here. Okay, but that was point number 3. 25% of the essay, which takes us to point number 4, which was worth 30% of the essay. Here, the bar examiners were looking for examinees to conclude that the Confrontation Clause prohibits the use of the sister's statements to the officer because they are testimonial. The objective primary purpose of this interrogation was not to address an ongoing emergency, but to establish past events potentially relevant to a later criminal prosecution. Again, remember our trigger events we look out for with the Confrontation Clause, right? And remember too, macro big picture, Confrontation Clause, we should always kind of think about as a potential issue in our hearsay analyses where we see out-of-court statements coming into a criminal prosecution where the people who made those out-of-court statements are unavailable for cross-examination. We should always think that could be a violation of the Sixth Amendment Confrontation Clause. And again, if we want to think about this elementally, we can think about this in terms of kind of 4 elements to get to our conclusion. The first 3 elements are really like our trigger events. Number 1, we have to make sure it's a criminal action, not a civil action. Number 2, that the declarant actually is unavailable. unavailable. Because if the declarant's available and subject to cross-examination, then it's clearly not a confrontation clause issue. Then our defendant is confronting the witness against him. We also have to make sure that the defendant did not have some prior opportunity to cross-examine the declarant. And finally, if we see all three of those are satisfied, which is the case here, then the analysis comes down to whether the out-of-court statement that's being offered was testimonial. Testimonial. And when we see statements made to police officers, the giveaway here is going to be whether the statement is made for the primary purpose of collecting evidence, or to provide assistance in an ongoing emergency, right? And here, this is what the bar examiners are saying. The statements are testimonial because the objective primary purpose of this interrogation was not to address an ongoing emergency, but to establish past events potentially relevant to a later prosecution, basically for the purpose of collecting evidence to be used against the boyfriend in a future criminal prosecution, which makes the statement testimonial, which makes this a violation of the Sixth Amendment Confrontation Clause, because we have a criminal action. The proceeding is a criminal action. The declarant is unavailable to be cross-examined at trial. The defendant did not have the opportunity to cross-examine the declarant at a proceeding prior to the trial, and the statement is testimonial for the purpose of collecting evidence to be used in a future criminal prosecution. So that's how we got to this was a violation of the Sixth Amendment Confrontation Clause. To me, the biggest fact here that I was kind of looking for, at least as I read this, is when does the emergency situation end? Especially in something like this where it's a domestic violence incident. As I'm reading this and I'm thinking about domestic violence, in my head I'm thinking, well, at some point this guy's going to be subdued and the emergency situation is over. So any statements made beyond that point, by definition, cannot be for the purpose of assisting in an ongoing emergency because the ongoing emergency is over. And that, to me, happened at this point in time, where the boyfriend sat in the patrol car and the officer locked the door from the outside so that the boyfriend would stay in the car while the officer spoke to the sister. So the statements the sister's making to the officer now cannot be for the purpose of providing assistance in an ongoing emergency, unless she was like bleeding and was needing an ambulance or something. That's what it was all about. But it looks like the emergency situation's over, right? The boyfriend is subdued. She's declining the need for medical assistance. And the statement really now seems to be about the collection of evidence, right? Officer asked how she got the cuts. She's saying the boyfriend threw a bottle at her, which cut her arm. That looks like about the collection of evidence. It's not to provide assistance in an ongoing emergency because she's declining, the medical assistance. So there's no medical emergency and the threat has been subdued. The boyfriend who's causing the violence has been, put in the car and is locked up. Her medical needs seem to be addressed and fine. So this really now seems like the primary purpose of this statement is for the collection of evidence, which makes the statement testimonial. Because we have an out-of-court statement being introduced in a criminal proceeding, the declarant is unavailable to be cross-examined at trial. The defendant did not have the opportunity to cross-examine the declarant at a proceeding prior to trial. And because the statement is testimonial, that's how we got the violation of the Confrontation Clause, which prohibits the use of the sister's statements to the officer. Okay, that was point 4, worth 30% of this essay. So with that, this was everything the bar examiners were looking for on this July 2013 multi-state evidence essay exam. With that, I'll leave you all to it. I wish you all the absolute best, and I'll see you at our next lesson.